We now proceed to the three seats on the Court of Appeals. Again, the first seat is that which is designated at the Board of Elections as the McGee seat and currently held by Judge Linda McGee. And we will hear from Judge McGee and then David Robinson. We've asked these two candidates to address the following. Black's Law Dictionary defines judicial activism as a philosophy of judicial decision-making whereby judges allow their personal views about public policy, among other factors, to guide their decisions. Do you believe there are times when it is appropriate for a judge to incorporate his or her personal views on issues to guide their decisions? Judge McGee.
Good afternoon. My name is Linda McGee. I have the honor of serving on the North Carolina Court of Appeals, where I have served for the last 17 years. I want to thank you for this special opportunity to share some information about me with you. I appreciate the chance to have your endorsement in the past. You have kindly honored me with that, and I also appreciate the support of many of the people in this room over the years. You have welcomed me to your great events down at Hilton Head on a frequent basis. You have also given me the opportunity to speak at your CLE programs, most recently one for the young lawyers on appellate practice that was held at Campbell Law School in Raleigh recently. Let me share with you, if I might, a little bit of my background. As I said, I have been honored to serve on the Court of Appeals for 17 years. The Court of Appeals has the opportunity to hear a varied kinds of cases all across the board. I had the special honor of being able to serve, the opportunity to be able to be a part of a law firm in Boone, North Carolina for 17 years, where I had a very varied practice of law. I was in and out of courts on a day-to-day basis, criminal and civil, which gave me a great experience, good background for the kinds of things that we're here at the Court of Appeals, because as you well know, our cases there are certainly very varied. I grew up in a small town in western North Carolina in a mill village area, in a place where it was important, and we quickly learned that hard work was something that you could value. We learned to be able to work with one another well and come out with a good outcome. That's something we also do and try to make use of on a regular basis at the Court of Appeals. I was the first person in my family to have the opportunity to go to college. I went on a scholarship, and I'm a double Tar Heel, had the opportunity to finish in a 6-year time frame where they used to have a special place where you could just basically not go through your senior year. Wouldn't mind having that year back now, but it worked well because I was about to be married and it was on scholarship. After I practiced law for 17 years in Boone, I had the honor of being appointed to the North Carolina Court of Appeals when there was a vacancy. I have now run 3 statewide races and have served for 17 years. I would like to tell you that it gets easier when we're going through these statewide races, but it does not. It is a challenge without any question, but it's a great learning experience and a great opportunity to be able to meet people all across the state. Now, the question about judicial activism. May I tell you that it was frequently called an issue that is in the eye of the beholder. But it is nice to see that we have a definite definition from Black's Law Dictionary that tells us that we're talking about the possibility of inserting your personal opinion when you're trying to make a decision. At the Court of Appeals, I have been involved in more than 6,000 decisions over the last 17 years, and I have written more than 2,000 opinions. I believe that you could look at those opinions and determine that I do not insert my personal opinions. It is not the place for judges to be able to bring in their biases, their personal opinions, and when they're making decisions about people's lives, when they're deciding things that are important to individuals, to businesses, to families. That's just not the place for the personal opinion of the judge. The opportunity to be able to share your personal opinions, quite frankly, at a public forum like this, for instance, is also not appropriate because of the fact that it is highly likely, based on the kinds of cases that the Court of Appeals receives, that we're going to hear that kind of issue sometime in the future. If, in fact, somebody has made a statement about a particular issue, it is going to be difficult for people to believe when they bring their cases to the court that they had a fair hearing if they know that a judge has spoken out on an issue. So public statements about personal opinions have no place in a judicial race. Now, might I share with you a little bit about my public service and my involvement since I've been on the Court of Appeals. It is important to me that we share the work of the court with people in the public. So I have had the pleasure of being able to speak to civic groups across the state. I have served as chair of the Civic Education Consortium at the School of Government, and I've been very active in the North Carolina Bar Association's Lawyers in Schools program. I know how important civics are. I know it's important that young people understand not only their legal rights, but also their legal responsibilities. I also believe strongly in access to justice. I had the opportunity when the first Chief Justice Equal Justice Commission was formed to be appointed by the Chief Justice, I. Beverly Lake, and reappointed by Sarah Parker. What we do is we try to focus on issues that give the opportunity for people all across the state, no matter what their economic level, to be able to make use of our court system. I have felt those are important issues that we must deal with. I have an experience of 17 years on the Court of Appeals. I have been in the courts of our state for the last 35 years on a daily, regular basis. I hope you will agree with me that experience makes a difference for judges. I think being consistent, straightforward, clear in opinions is something that you can count on from me. I have appreciated your support in the past. I ask for it again, and I hope that you will do so. Thank you for the opportunity to be with you this afternoon. Thank you.
David Robinson.
I'm David Robinson, and I'm running for the Court of Appeals. I respectfully request your vote. I want to thank the NCADA and the North Carolina Chamber for inviting us here today. Perhaps most importantly, I want to thank each of you for taking time out of your busy schedules to care enough about our judiciary and about this judicial process to be here today. Thank you. When we elect a new president in this country, there's always some speculation as to what country are they going to visit first as president. Just coincidentally, my first event as a judicial candidate was to the 70th annual meeting of the North Carolina Chamber. There I heard repeatedly, working together, North Carolina can win the jobs race by proclaiming we are open and ready for business. 70 years is an impressive legacy, and I commend you on your successes. Most of your efforts are understandably legislative: workers' comp reform, reducing regulatory burdens, tort reform, and right-sizing state government. But the judiciary also plays an important role in positioning this state for growth and for stability. We do this, especially at the appeals court level, by maintaining a level playing field for all North Carolinians and their businesses, rolling the dice to see if one can get an appeals court judge or two to substitute their own subjective fairness standard for laws written by a legislature is bad for business, and it's bad for North Carolina. I'm a general business lawyer. I've been practicing in Raleigh for over 2 decades. I started with the largest law firm in the world, Graham & James, moved on to Moore & Van Allen, and spent a decade working out of a home office as a sole practitioner, changing my own toner cartridges and trying to stay away from the refrigerator. I'm now special counsel with Nexen Pruitt, a 190-lawyer firm with 8 offices throughout the Carolinas. I want to do just a quick shout out to Nexen Pruitt because they have been most gracious in allowing me to follow this dream of mine, and they said if it's good for you, it's good for us, and I really appreciate in a public forum as often as possible my partners at Nexen Pruitt. I've helped dozens of small businesses get started, and I've helped companies grow and merge. I get involved in corporate and securities issues, labor and employment issues, IP portfolio issues, and international law issues. I've helped North Carolinians merge hospitals. I've helped them sell hot tubs in Saudi Arabia. And I proactively help them manage the affairs of their corporations. I do pro bono work for religious and charitable organizations, including right now homeless veterans, churches, medical mission work, and disaster relief organizations, which is a particular hobby of mine. In my spare time, I've been married for 20 plus years to a wonderful woman, have 3 exemplary teenage daughters, and I've also managed eventually to become an Ironman triathlete. I've also been to 50-plus countries. I'm qualified to be a Court of Appeals judge. I'm eager to serve, and it would be a privilege to serve if the North Carolina voters choose me to do so. In the invitation to speak here today, you've asked a serious question about judicial activism, and now the nature of running for public office as a judge in North Carolina suggests that I maybe sidestep or water down my response, but a serious question deserves a serious response. I believe the state of North Carolina benefits from judicial restraint, not activism on the Court of Appeals. We correct mistakes. We keep the playing field level. To vilify judicial activism, however, we have to define it. To use George Will's introductory statement when he addressed the Raleigh Chamber of Commerce annual meeting last week, let me take you to a crime scene, 2 actually. In 1947, Justice Hugo Black penned Everson versus Board of Education, and whether you agree with the application of the 14th Amendment or other parts of the Constitution or not, or whether you believe that the 10th Amendment really means anything anymore, you clearly in that case had a judge with an objective in mind and really no question about stretching historical facts. Making things up to support a court opinion is judicial activism. The second, all too prevalent form of judicial activism in this country is perhaps most recently embodied in the PPACA decision, sometimes known as Obamacare. This case, again, whether you like the holding or not, is a clear legislative compromise masquerading as a judicial opinion. Checks and balances are important. They're the brilliant cornerstones of our republic. A defective law should be returned to the legislature, not improved upon by the judiciary. So, do I believe a North Carolina Court of Appeals judge should allow their views about public policy to guide their decisions? No. Now, since I have just a tiny bit of time left, and since I know that the NCADA has an interest in judicial election selection, maybe, I just wanted to offer this candidate's perspective. Yes, it's awkward to ask for money, and yes, it is a tremendously big state. It is a lot of work to be a candidate. But I assure you, it's been both a privilege and a blessing to meet people. They may not understand exactly what the Court of Appeals does day in and day out, but they care about this branch of government, and it has been nothing but a pleasure having an opportunity at microphones to address people as I've traversed this state. I'm David Robinson, not the famous basketball player. I am not that David Robinson either. I am David Robinson, the business ethics professor, a former section chair of the Bar Association, and I would appreciate your vote on November 6th. Thank you.